All
Well,
right.
on that note, I see we're top of the hour here and attendees starting to filter in. So I want to welcome everybody to our latest TMC Connect broadcast today. It's a special Valentine's Day edition, bringing up the fourth annual Johnston Thomas and TMC regulatory compliance roundup. And those less familiar, James Brody, mortgage banking practice chair with Johnston Thomas, always been a great friend and partner of the network, puts together these annual roundups, really looking to tap into some of the most hot button issues from a regulatory compliance standpoint that's facing our industry in the year ahead. And really for this edition, just knowing how challenged everybody is in the current economic downturn. James has got a ton of great content, insights in store for you, heavily focused on tips to kind of weather that storm of this current downturn, while not sacrificing compliance as a part of staying cost friendly. So on that note, want to welcome James in. James, appreciate you taking the time to share your knowledge with our membership as always, and excited for what you've got on deck for us today.
Hey, thank you very much, Tom, and good afternoon, everyone. I'd like to thank all of you for dialing in for today's webinar. It's titled Annual Regulatory Roundup, Invaluable Tips to Weathering the Economic Downturn While Staying Compliant. I know it's a mouthful, but at the end of the day, I'm hopeful and confident that you'll find the information reviewed today to be helpful as we all continue to navigate the ever-changing world of regulatory compliance in our mortgage banking industry. Before we begin, as is customary, anytime a lawyer gives any presentation, I'd like to first give a quick disclaimer that nothing in today's presentation constitutes legal advice or creates an attorney-client relationship between our office and today's attendees. Next slide, please. Now, for information on myself and our mortgage banking practice, if you're not already familiar with us, please feel free to look over these slides after you receive a copy of the PowerPoint from today's presentation, which you will be able to obtain at the conclusion. And also, if we're not able to get to any questions and answers today, because there is a ton of information I'm going to try to get through, it may very well even go over. But if you're not able to ask those questions and get your answers, please feel free to send them to Tom or myself. And as we usually do, we'll be happy to prepare a follow-up FAQ to try and address all of those. With that being said,
and James, real quick, I would just add too for our attendees.
Yeah.
If you want to in real time, you can feel free to put any questions you may have within the chat or the Q&A function if you're with us on Zoom. And to James' point, if we run out of time to be able to address anything laid out within the chat or Q&A, we will have transcript there and can look to address those inquiries and follow up.
Yeah, that sounds great. And with that, Tom, why don't I go ahead and turn it over to you? Maybe you could give a quick introduction for the collaborative as well as yourself, and then we'll get the show on the road.
Happy to, James. Certainly appreciate it. Well, Tom Gallucci, Senior Vice President here at TMC. Been with the firm for about 7 years now and have the pleasure of running our preferred partner network of 68 partners strong, really best-in-class firms across the industry with unique solutions that support our members as part of my day-to-day here with the collaborative. And just real briefly, for those that may be less familiar with TMC, what I can tout to you at a very high level, really the largest independent cooperative network out there, solely focused on serving the mortgage banking industry with a membership of over 260 lender members, with a strong mix of IMBs, depositories, and credit union members alike. And as the slide lays out, I think what uniquely makes TMC different than any other association you may be engaged with in the industry is that we're not really out there selling products or services. just by our independent nature there. Really what we look to do is bring a slate of benefits to the table for our lender members, designed based on their feedback to help address challenges that they're currently facing, bring best-in-class solution providers to the table that can address their needs, and be a dedicated resource for creating avenues for peer-to-peer networking, whether you're lender member to lender member, preferred partner to partner, or anywhere in between, whether it's at a C-suite level or down to departmental management. Really focused in providing an avenue for the resources that you need to keep your business not only compliant, as we're going to talk about today, but as efficient as possibly can be, as well as maximizing profitability out there. Before I turn it back to James here real quick, I'd be remiss if I didn't give quick plug for our upcoming conference, Stay Classy with TMC at the Intercontinental Hotel in San Diego, March 5th through the 8th. TMC members, still time to register and come join us out there. Certainly would love to have you there. And James himself is going to be leading a breakout session in Monday afternoon's agenda at the conference on March 6th around avoiding loan buybacks and optimizing loan quality. So always great content in person, and not only from James, but leveraging the collective feedback from lender members and partners alike in the rooms, as we like to make our sessions very interactive there. So love to see your faces out there in sunny San Diego in just a couple weeks. And my last collaborative plug just would be for our newest offering, which is TMC University. Really great educational content based on the feedback from our members, of a really strong need to provide more customized, tailored content, not only on the business development side, but strategic communication, such things as sales call reluctance for loan originators, and continuing to build out more content based on what you tell us your teams need to operate most efficiently. So certainly feel free to reach out if you're ever looking for more information on TMCU. And then for our members not currently working with James and his firm at Johnston Thomas, very unique benefit of our partnership. Like many partners, James and his firm have great benefits to the members on any sort of litigation, regulatory compliance, or other related needs that fall into Johnston Thomas's wheelhouse. But for all TMC members, whether you're a client or not with Johnston Thomas, James and his firm do offer up a pair of 30-minute complimentary consultations. So if there is a topic out there that you're looking for some insight on from, compliance, regulatory, or legal standpoint, don't be afraid to pick up that phone. I know some have sales call legal call reluctance, if you will, afraid that if they call an attorney, that the moment that phone call is answered, there's a bill invoice on the way. So James and his team want to be really resourceful to our members, and would just highly encourage folks out there, if there is a topic that comes to mind, do not hesitate to reach out to James. It's been such a great partner to us over the years.
All right. Well, listen, thank you very much, Tom. And without further ado, we'll launch right in. So, as much as 2020 and 2021 proved to be record-breaking years and for production and profits in the industry, we can see the industry trends doing really a 180 in 2022 and through the beginning of 2023. In short, mortgage demand dropped to a 22-year low, with higher interest rates and inflation contributing to a crush on the home buyers. Now, with this trend set to continue through much of 2023, and people's predictions have varied, there's also the increase in regulatory scrutiny that's been promised and rolled out under the Biden administration and the returning leadership at the CFPB. Now, when mortgage bankers were earning record profits, it was relatively easy for companies to invest the time, the money that was necessary to ensure that your companies were able to continue to stay compliant. However, with mortgage bankers once again being forced to endure another economic downturn that is likely to persist throughout much of 2023, There are many that have felt they needed to sacrifice compliance in order to ensure their companies are able to stay afloat. As a result, the purpose of this year's regulatory roundup, as Tom had mentioned, is to address how you can maximize your profitability without having to sacrifice compliance and end up cutting off your nose despite your face. Now, as we've seen time and time again, mortgage bankers whose companies sacrifice compliance in exchange for the short-term gains really run a much higher risk that their companies will not survive to reap the profits during the next economic boom, which will inevitably follow as it does with every cycle. Now, some of the many issues that will be discussed during this webinar include LO comp, dual employment, marketing service agreements, non-compete agreements after the FTC announcement, the always present risk of consumer privacy, the CARES Act, fair lending, and really audit preparedness. Next slide, please. Now, as we know, the original LO comp rule went into effect in January of 2014. However, despite the fact that the rule has been in place for many years, some changes and evolution of the rule have taken place, and we continue to receive more inquiries about LO comp than any other rule. It's with this in mind that I want to provide some additional information for you here. First, the rule prohibits a lender from compensating an LO based on the loan terms or a proxy of loan terms other than loan amount. And when determining if a factor is a proxy for a term of a transaction, really there is a two-part test that you have to engage in. A factor is a proxy for a term of a transaction if the factor consistently varies with a term or terms of the transaction over multiple transactions. And two, the LO has the ability either directly or indirectly to add, drop, change any of those factors when originating the transaction. Remember, this is a two-part test that you have to engage in. Now, the rule also prohibits compensation from both the consumer and another person, meaning the LO cannot receive a commission from both the borrower and the company, for example. Next slide, please. Now, the rule did provide 7 examples of what would not be considered a proxy of a loan term, which are reviewed here. And of course, the Bureau indicated that these 7 are not an exhaustive list, but if it's not on that list, you really should be exercising some level of caution and making sure that you consult with your counsel, your in-house compliance person, or what have you. Now, payment based on the LO's overall volume, either their total dollar amount of extended credit or the total number of transactions originated during a specific time period, is indeed permissible. Long-term performance of the LO's originations is permissible. Hourly rate of pay to compensate the LO for actual hours worked. And keep in mind here, it's acceptable and very common to pay a base rate for hours worked on top of a commission that's earned. And whether the consumer is an existing customer of the creditor or a new customer is also permissible. Paying a flat fee for every loan originated. Now, keep in mind here that this can be tiered. For example, for 0 to 5 loans originated, the LO will receive $200 per loan. 6 to 10 loans, $250 per loan. And for more than 10 loans, say $300 per loan. Number 6, the percentage of applications submitted that actually close. And then for the last and final one that was exhibited as examples, the quality of the LO's loan files, such as accuracy and completeness of the loan documents. Next slide, please. Now, I want to quickly go over some examples of popular permissible compensation structures, but also structures we commonly come across that we recommend avoiding. And first, I'll go over the permissible structures. First, plans that vary by loan officer. A question that we frequently get is whether you can pay your originators in the same state or the same branch different amounts. And the answer is yes. Some originators are just better than others, and the amount you pay to each may vary from one state to another, or even within the same branch. There's no requirement that you pay all your originators the same amount, simply that whatever you pay any given loan officer complies with the LO comp rule. Second bullet. toggling between borrower and lender paid. Now, we've been asked frequently as well whether you can allow a broker to choose borrower paid compensation on one transaction and lender paid compensation on another in the same day or month. And the answer again is yes. Your LO can toggle back and forth between borrower paid and lender paid compensation from transaction to transaction. And according to the rule and the commentary, the prohibition against dual comp is transaction specific. Of course, that being said, as a lender, you will need to ensure that you have proper oversight of this. And we recommend once a transaction starts off one way, it will remain that way. Plans that provide for a minimum and maximum compensation per transaction. Now, you can set up plans that provide for a floor and a cap so long as these minimums and maximums do not vary with each transaction. So, for example, it's permissible to pay your LO 1.25% of the loan amount as compensation, subject to a $1,000 minimum payment and $5,500 maximum payment. Now, what about sign-on bonuses as well as initial guarantees? We do receive a number of questions inquiring whether a newly hired LO can receive a sign-on bonus or a question verifying an LO can receive a guarantee during a specific period of time. These are both permissible and really quite common. Pick a plan structures. In this instance, an LO is presented with multiple compensation plans, and the LO can elect which plan they want to get paid on. Now, this is permissible so long as none of the plans presented to the LO independently violate the LO comp rule. What about periodic plan changes? So it's important to understand that you can modify your LO comp agreements. That being said, we recommend you don't change plans frequently. And for retail plans, we recommend not more than once every 6 months, but certainly no more frequently than quarterly. Also, it's important to note that any changes apply prospectively only, meaning the comp will apply only to applications taken on or after the date of the change, lest you get in some trouble for dealing with compensation that has already been earned. What about lead source options, which is very common when we're talking to our clients about LO comp and trying to give them some ideas of ways that they can address questions by their LOs. The LO comp rule doesn't prohibit compensating an LO differently on different transactions, provided that the difference is not based on a term of a transaction or a proxy of a term. Now, when LO comp is based on any other characteristic or attribute not specifically listed as a safe method, the company needs to review to determine if it is really a proxy for a term. Now, lead sources are typically compliant if implemented uniformly and in a consistent manner. So the most common way of doing this is to clearly identify and track the source of the lead at the very beginning. Additionally, the company should have clear policies regarding lead source and compensation, and the source can't be identified or associated with any loan terms or products. Okay, what about non-permissible structures? Now, I want to quickly review some structures that we would recommend against implementing. Remember that the LO comp rule prohibits basing the LO's compensation on a term of a transaction. So terms include interest rate, APR, qualifying credit score, amongst many others. Now, when you're looking at a loan product, it's really essentially a bundle of loan terms. So if you vary your LO's compensation by loan product, it's possible you are basing the pricing on a few loan terms that make up the bundle of terms which we call the loan product. Sliding scale percentages. Whenever paying LO comp based on a percentage of the loan amount of specific transactions, the percentage must be fixed and cannot vary with the amount of credit extended. For example, you can't pay an LO 1% for loan amounts more than $250,000, 1.5% for loans between $150,000 and $250,000, and 2.5% for loan amounts less than $150,000, or more than, less than. Varying compensation based on sold versus retained portfolio. Now, since lenders typically choose whether to sell or hold a loan based on the loan terms, for example, holding in portfolio 7-1 ARMs, but selling 30-year fixed. or holding in portfolio loans that are conventional but selling loans that are FHA. Now, since the LO usually advises the borrower which type of loan to choose, this would be considered a proxy of a term of a transaction. In fact, this is a scenario that was specifically outlined by the CFPB to illustrate what a proxy for a loan term is. Compensation pools. Paying a bonus to an LO out of a bonus pool based on the lender's profits from all of its LOs is not permissible. In these situations, you're simply compensating the LO based on the terms of multiple transactions by multiple LOs. And this is another example the CFPB had explicitly set forth when it was going through what is not permissible. Next slide, please. Now, what about the gray areas? Because there are many, and everyone knows that not everything is black and white when it comes to regulations and the CFPB. So I want to quickly discuss about 4 different areas or practices which fall into this gray area. Now, the first 2 may be permissible, but we recommend exercising enhanced caution when implementing them. The first is varying compensation by state. While this is not expressly prohibited, it is possible that it could give rise to fair lending concerns or be a proxy for a term of a transaction. And I'll give you an example. If you have a higher proportion of borrowers of a protected class in one state versus another, and LOs receive more compensation at a cost to the consumers in those states, it could result in unintended fair lending violations. Now, the second is reducing compensation to cover fees such as rate lock extensions or fee tolerance cures. While updates to the rule have clarified this is permissible, it is only permissible in very specific situations in which the change was a result of unforeseen changes. Now, the burden of proof will be on the lender to demonstrate this. As a result, we typically caution all of our clients against implementing these types of provisions just to make sure that you stay safe. But then again, depending upon the need and depending upon how far you are willing to push the envelope, it will really be a business judgment call. Now, the next 2 examples I put out are plan elements that are questionable and we recommend avoiding. The first is EPO and EPD clawbacks. The rule doesn't expressly address this, but it does say that compensation should be set in advance. Additionally, clawback provisions have the potential to violate state-specific employment and wage laws. As such, we highly recommend against this. Keep in mind that you can, however you want, change an LO's comp prospectively based on the historical performance as an alternate approach. And the second is paying differently for purchase versus refinance. While this is not expressly carved out as prohibited by the rule, it's certainly possible it would be considered a proxy for a loan term or bundle of terms, as we had noted earlier. A lot of times our clients ask about clawbacks. And there's a number of ways to achieve that, but it's not technically a clawback. You're looking again prospectively based on elements of the prior production to determine how it should be compensated moving forward. Now, lenders should also keep in mind other employee options that may be beneficial, such as exemption options. All right, next slide, please. Okay, FLSA exemptions. Most employees are entitled to be paid minimum wage. They're also entitled to overtime wages when they work more than 8 hours in a workday, more than 40 hours in a work week, or more than 7 consecutive days. This is governed by the Fair Labor Standards Act. In the most recent updated rule, the Department of Labor is raising the standard salary level from the currently enforced level of $455 per week to $684 per week, equivalent to $35,568 per year for a full year worker. Also raising the total annual compensation requirement for highly compensated employees from the currently enforced level of $100,000 per year to $107,432 per year. Now, the FLSA does include exemptions. The duties test, which require that employees meet certain duties requirements in order to be exempt from overtime, hasn't changed. In addition to the expressly enumerated job types, the FLSA states that employees employed as bona fide executive, administrative, professional, and outside sales employees and certain computer employees may be considered exempt from both minimum wage and overtime pay. These are sometimes called white-collar exemptions. Next slide, please. Now, the Fair Labor Standards Act exempts from its minimum wage and overtime standards employees who qualify as outside sales employees. And this is something that comes up all the time when we're doing LO comp agreements. There are nevertheless important criteria outlined in both federal and state regulations that must be met before an employee can be classified as an outside salesperson. Now, when those criteria are not satisfied, the exemption does not apply and normal wage and hour laws must be followed. For example, for an employee to qualify for the outside sales employee exemption under these regulations, the following criteria must be met. Must have the primary duty of making sales or obtaining orders or contracts for services or the use of facilities. Must customarily and regularly perform his or her primary duty away from the employer's place of business more than half of the working time. And although there are several criteria, location really seems to be the most critical in the analysis. Now, paying overtime compensation to an LO can be a complex, difficult, and cumbersome task. LOs often work non-standard, flexible, or changing schedules, seeking to be available to potential borrowers, realtors, and others at almost any time of the day. Keeping track of constantly changing hours can be tricky, at the very best of times. So this is added to a compensation structure that may involve multiple compensation methods and compensation standards. Now, a mix of compensation types is a competitive way to retail top talent, but it makes the calculation of their weekly overtime rate of pay a real challenge. So job titles don't determine the exemption status. And in order for an exemption to apply, an employee's specific job duties and salary must meet all the requirements of the Department of Labor's regulations. Now, what I will also go ahead and note here is that, if your LO's place of business is designated as his or her home, that may not qualify as being for outside sales. And you have to spend more than 50% of your time away from your designated place of work. So that is a big concern. And while this exemption applies to both overtime and minimum wage, we will usually caution our clients against trying to get around minimum wage. And that's because the state laws can tend to be very tricky. And if you fail to pay the minimum wage, you could end up with a fairly small claim that's also attached to a request or demand for attorney's fees, which could end up being much larger. And so we generally say not to use it as an exemption on getting around minimum wage, but as far as overtime, absolutely. All right, next slide, please. One more. So now I'm going to talk a little bit about dual employment, dual capacity, and conflicts of interest. It's not common that the industry change or announcement happens so close to this regulatory roundup webinar, so this may be new information for many on this webinar. This past December, the FHA announced updates to its single-family housing policy handbook that modified its policies governing conflicts of interest and dual employment. Now, the language specifically says employees are prohibited from having multiple roles in a single FHA insured transaction. Employees are prohibited from having multiple sources of compensation, either directly or indirectly, from a single FHA insured transaction. And the language that the mortgagee must require its employees to be its employees exclusively, unless the mortgagee has determined that the employee's other outside employment, including any self-employment, does not create a prohibited conflict of interest. This was removed from the HUD handbook. It was replaced with the language that employees will be subject to FHA's conflict of interest policy, which states participants that have a direct impact on the mortgage approval decision are prohibited from having multiple roles or sources of compensation either directly or indirectly from a single FHA insured transaction. Now, the significance of the change is that the modifications both seem to narrow the employees who are subject to the conflict of interest policies and impose what appear to be more significant restrictions on those employees. The announcement included that participants that have a direct impact on the mortgage approval decision are underwriters, appraisers, inspectors, and engineers. Now, the announcement went on to say that indirect compensation includes any compensation resulting from the same FHA insured transaction other than for services performed in a direct role. Some examples of indirect compensation, these would include compensation resulting from an ownership interest in any other business that is a party to the same FHA insured transaction, or compensation earned by a spouse, domestic partner, or other family member that it has a direct role in the same FHA insured transaction. Now, under the modified policies, those restrictions on compensation continue to include spouse, domestic partner, or family member with a direct role in the same transaction. And a family member is further defined as a child, parent, or grandparent. Next slide, please. This may seem like a short list, but that list includes step, foster, adopted, placed by an agency. And the actual definition reads like a laundry list. And I'll not bore you by reading through that, but you have it on the deck, and I welcome you to peruse that. Next slide, please. So you may have noticed a few areas of the new guidance that sticks out to you. The participants didn't include the owners, and you have to think, was this a mistake or an oversight? We don't really know. But it does seem unlikely that the regulators consider inspectors to have more influence on loan approval than owners. Now, the list of associated family members includes family of the borrowers, and this deviates from RESPA that says borrowers can't be perceived as receiving kickbacks since they're a party of the transaction, but now their family members are a source of indirect compensation. Additionally, the existing policies addressing for underwriting and quality control staff, the reporting structure for underwriters, and the conflicts of interest for home equity conversion line originators, that remains unchanged. Now, FHA lenders should take a careful look at the parties subject to the new policies, or that could be subject to the new policies, in order to assess if any changes in operations are necessary or appropriate. Next slide, please. Okay, one more. Okay, we can't start talking about marketing service agreements without really first talking about RESPA. RESPA Section 8 is a prohibition against kickbacks and unearned fees. This section will concentrate on today that says no person shall give and no person shall accept any fee, kickback, or thing of value pursuant to any agreement or understanding, oral or otherwise, that business incident to or a part of a real estate settlement service involving a federally regulated mortgage loan shall be referred to any person. So RESPA was enacted in order to eliminate abusive practices such as payment of kickback fees, which drive up the cost of the products for the consumers. And there are really 5 elements that are listed as part of Section 8 that evidence a thing of value, which is pursuant to an agreement or understanding, and refer to settlement services in connection with a federally regulated mortgage loan. Now, it's important to note that any agreement or understanding for the referral of business incident to or part of a settlement service need not be written or verbalized, but may be established by a practice, pattern, or a course of conduct. And when a thing of value is received repeatedly and is connected in any way with the volume of value or value of the business being referred, the receipt of that thing of value is evidence that it is made pursuant to an agreement or understanding for the referral of business. Now, under Section 8C, RESPA does not prohibit payments for services rendered or goods and facilities actually provided. Goods, services are actual, necessary, and distinct and payment must be commensurate with the value of the goods and services. You can't just pick that service and, give some random value. It has to have some logical connection, to what is being paid for. Next slide, please. Oh, you got it. So key RESPA terms. Additional definitions that are key to understanding RESPA requirements are referral, which is essentially any oral or written action directed to a person which has the effect of affirmatively influencing the selection of a provider of a settlement service when that person will pay for the settlement service. This definition also includes required use of a particular provider. Now, the phrase thing of value. Things of value has a broad definition. Doesn't require, but could be a transfer of money. It includes any payment, service, or other consideration, such as things, discounts, salaries, commissions, fees, duplicate payments of a charge, stock distributions, the opportunity to participate in a money-making program, services of all types at special or free rates, trips, payments of another person's expenses, and so on. It also includes quid pro quo arrangements. I refer to you, you refer to me. All right, next slide, please. Potential liability under RESPA. Unlike violations of other RESPA provisions, Section 8 violations may result in criminal penalties as well as substantial civil penalties. And examples of penalties include fines of up to $10,000, imprisonment for up to a year, and treble or triple damages. Violations of RESPA Section 8 also expose both corporate entities and their individual employees to significant potential liability under RESPA and the Consumer Financial Protection Act. Both parties to a prohibited relationship under RESPA Section 8 are subject to its restrictions. Now, the language of the statute says no person shall give and no person shall accept any fee, kickback, or other thing of value in exchange for a referral, and therefore either or both parties may indeed be liable for any of these violations. Next slide, please. RESPA Section 8 impacts virtually all of your relationships with business partners and referral sources, including marketing services, including MSAs and co-marketing arrangements, affinity arrangements, including single entity advertisements, office desk rental agreements, purchasing and selling of leads, affiliated business arrangements and joint ventures, referrals by any person, including consumers, nonprofit organizations, affinity groups, or other non-settlement service providers. It impacts interactions among lenders, real estate agents, home builders, and title companies, amongst others. All right, next slide. Now, advertising for mortgage or other loan products is a highly regulated activity in the financial industry, and we often review our clients' advertisements to make sure that they are compliant. In addition to RESPA, there are multiple other federal regulations that play a part in marketing and advertising compliance, and these include Regulation Z, Truth in Lending, Regulation N, Reg B, UDAP, SAFE Act, Fair Lending, and Redlining. And these regulations create a variety of nuances that lenders are expected to adhere to. Restricted words and phrases, along with buzzwords and trigger terms, really are a slippery slope that can lead to visits from regulators and possible violations. Now, the phrase "I didn't know" is obviously not a valid excuse for regulators, so it's worth the time and effort it takes to protect your organization from the fines and penalties that result from noncompliance. So, again, the idea here is not to try to break your backs with, burdensome regulations, but to understand that by paying mind to these regulations and doing what needs to be done, you are setting yourself up for success as we, again, roll out of this cycle, which we eventually will, as we do with every cycle. And so the last thing you want is to make it through this cycle and end up getting a big hit because of, you're not paying attention to the necessary regulations. All right, next slide, please. What is an MSA? An MSA is a popular and sometimes whispered phrase in the industry. A marketing service agreement, or MSA, is an agreement between a lender and a marketing partner to provide the lender market exposure to the marketing partner's customers. So that leads us into the next question: what constitutes marketing or advertising? Well, advertising and by association marketing is regulatorily defined as a commercial message in any medium that promotes, directly or indirectly, a credit transaction. And that definition includes any written or oral statement, illustration, or depiction of any kind that is designed to effect a sale or create interest in purchasing goods or services, wherever that message may appear. And this includes, for example, messages in newspapers, magazines, leaflets, promotional flyers, radio or television announcements, electronic advertisements such as on the internet or cellular network, and direct mail literature, amongst others, telephone solicitations, and so on. Now, I feel I should point out that it does not include personal contacts relating to the negotiation of a specific transaction. And I think that's important to keep in mind because that is prevalent here. Next slide, please. Now, interest in entering into MSAs has risen recently throughout all sectors of the industry due to three main contributing factors, which are: one, the significant increase in FHA net worth requirements has soured so many prospective affiliated business arrangement members. Two, the QM rules count affiliated charges toward the 3% cap amount. And three, there are several other advantages to MSAs that include the fact that there is no capitalization needed, no infrastructure required, and the payment is not tied to volume. Next slide, please. So earlier in this webinar, I mentioned that the catch-all exception included in RESPA Section 8, and that is that RESPA does not prohibit payments for services rendered or goods facilities actually provided. Goods and services are actual, necessary, and distinct, and payment must be commensurate with the value of the goods and services. Again, however, that exception does include a two-part compliance test in which you need to keep in mind anytime you're trying to consider whether this is compliant. And the first part of that test is that the payments must be made for services and goods that are actual, necessary, and distinct. And then the second part of that is that the payments must be commensurate with the value of the services and goods, as I mentioned a bit earlier. Now, services are part of RESPA Section 8C exception, cannot be for referral of business. Otherwise, it violates Section 8A. And then permissible services under a marketing agreement are advertising services. Determining fair market value, again, as I mentioned earlier, is critical to a compliant MSA. Payments in excess of fair market value are considered payment for a referral of business. So the payment must be commensurate with the value, and that is critical. The bottom line is that an MSA is not illegal. We prepare them for our clients all the time. Section 8C2 provides the legal framework to support a compliant marketing agreement, but there are requirements to ensure that a particular marketing agreement is and remains compliant. Okay, what about pitfalls? Next slide, please. MSAs can be extremely advantageous, but with those advantages comes possible pitfalls as well. Lenders should be aware of possible steering by the marketer and consequences for the lender. Conducting frequent adjustments to the MSA that may incidentally coincide with the appearance of steering, outside services being utilized by marketing partners, and other regulatory requirements for vendors, bad negotiation formation of the agreement in general that may leave lenders in bad legal positions, exclusivity and direct marketing practices that could be seen as violations of RESPA, poor monitoring, auditing of the services contracted for, and payment to the marketing partner regardless of the actual actions being completed because it's stated in the agreement. Okay, next slide, and we'll get into affiliated business arrangements. So an affiliated business arrangement exists when a person in a position to refer real estate settlement services has an affiliate relationship with or a direct beneficial ownership interest in an entity to which settlement business is referred, such as a joint venture or mortgage entity. Affiliated business arrangements are supported as an exception in RESPA Section 8, subsection C4. Most settlement service providers provide for joint ventures will fall within the broad RESPA definition of affiliated business arrangement. The general requirements of joint ventures and affiliated business arrangements is 1, to disclose the relationship, 2, ensure that your process does not include a requirement to use the joint venture, 3, the only thing of value is return on ownership interest and other compensation permitted under RESPA. Now, a major challenge in these arrangements is to properly implement and document in order to remain compliant. There is a multi-part test to documenting that a joint venture is bona fide as well. Next slide, please. Now, an affinity relationship is a partnership between a settlement service provider and a non-affiliated non-settlement service provider. This settlement service provider typically gets access to potential consumers through marketing efforts, usually offering an incentive, discount, or deal to the consumers. The non-settlement service provider gets to point their members towards discounted settlement services, and members get a discount on the settlement service offered by the settlement service partner. Now, when it's structured correctly, these relationships can be both mutually beneficial and RESPA compliant. Any benefits or things of value should go to consumers only. Incentives offered must be true incentives and cannot be offset by higher costs elsewhere. The offers must be applied consistently, and if providing the incentives, the funds must come from the referred party. Also, cannot be defrayed or offset by the referred party. Any offset by the referred party would be additional compensation. And in order to remain compliant, no compensation or other thing of value to non-settlement service providers under other arrangements between the parties. Okay, next slide, please. What about co-marketing? Well, co-marketing is when 2 or more parties are each represented in one marketing piece. An example may be a title company and lender are both represented in a flyer or online banner ad. Marketing provider may be either one of the co-marketed parties or an independent third party. And, for example, here, a third party website host or publisher of a newspaper of general circulation. Co-marketing is generally permissible under RESPA as long as certain parameters are met. You must pay for your pro rata share of advertisement. Section 8 permits normal promotional and educational activities that are not conditioned on the referral of business and that do not involve the defraying of expenses that otherwise would be incurred by persons in a position to refer settlement services or business that's incident thereto. That's a quote. You cannot give a thing of value in exchange for the referral of settlement service business. Free marketing is going to be a thing of value. What about office rental arrangements? Next slide, please. Office rental arrangements may include arrangements in which a person or entity that is in a position to refer or accept the referral of settlement service business rents office space within the building or office space of another person that's in a position to refer or accept the referral of such business. Under Section 8, you are required, or a company is required, to determine that office rental payments bears reasonable relationship to general market value of rental space provided and is not a disguised referral fee. An example is when there is a reduced rental payment or a required rental payment when market practice is not to charge rent. Rental payments may include appropriate proportion of cost for office services that are actually provided to a tenant, such as secretarial services, conference rooms, utilities, telephone, internet, or other office equipment. Again, this goes back to the fair market value, making sure that you are getting what you are paying for and not being used as a way to disguise it. Next slide. Lead generation agreements. These consist of just that, really paying for leads. A lead generator assists in identifying consumers who may be considering or interested in the products or services you're providing. An interest in lead generation really has increased as cost efficiency has become more necessary. Now, lead sellers help minimize the risk associated with ineffective advertising campaigns by selling the leads generated by their own advertising campaigns. Lead sellers typically incorporate marketing professionals so that their campaigns are usually more cost effective. Now, while paying for the lead is permitted under RESPA, paying for the results from the lead is not. The CFPB has scrutinized lead generation, including lead sales and lead purchases, and regulators have concerns regarding consumer privacy issues, as well as possible unfair, deceptive, or abusive acts or practices, aka UDAP. Next slide, please. All right, what about non-compete, non-solicitation, and non-disclosure agreements? On July 9th of 2022, President Biden ordered the Federal Trade Commission to fully ban or limit an employer's use of non-competes. I was just interviewed about this issue not more than a couple of weeks ago, because it is big news, although, it remains to be seen how it will ultimately, what the ultimate fallout and the ultimate rule will be. But when you're looking at the FTC, which regulates advertising, marketing, and consumer credit practices, and also prevents antitrust agreements and other unfair practices, you see that even though it doesn't have authority to punish violators, it can monitor compliance with trade laws, conduct legal investigations, issue cease and desist orders, convene public hearings, file civil suits, and ensure that the court orders are followed. Non-competes generally prevent employees from working in a similar role for a specified period of time. Some of the non-competes limit an employee's ability to work in the same geographical area for a specific amount of time and typically target executive level managers. What's more prevalent in the mortgage industry are non-solicitation clauses. Now, these clauses are designed to prevent an employee that departs the company from soliciting employees and trying to take other employees with them to a competitor. An example would be a branch manager that moves and tries to take all the employees that report to that branch manager with him or her. A non-disclosure agreement, also referred to as a confidentiality agreement, is also very prevalent in our industry. It lawfully prohibits the employees and independent contractors from disclosing any confidential information that they receive during their employment. Non-disclosure agreements serve companies to protect information about their operations, processes, secrets, or other information that is important to their market standing and competitive position. Now, the restrictiveness of non-competes and non-disclosure, non-solicitation agreements established if the contracts are enforceable in court and whether or not the restraint on the employee is logical. To date, non-competes have been dealt with on a state-by-state basis, with some states like California banning them altogether. Some prohibit lower wage positions, some limiting to inclusion, with other elements such as expensive training, while numerous others prohibit their use with low-wage workers. Now, many employers do include non-competes to discourage employees. Most cases where employers actually try to enforce the clause has to do with data theft and taking consumer information to other companies without the consumer or previous employer knowing about it. When this declaration by President Biden first came out, there was a lot of speculation that anything resulting from the order would be overly broad and include banning non-solicitation or non-disclosure clauses. But that doesn't seem to be the case here. On January 5th, 2023, the FTC proposed an expansive new rule, which would impose a near complete ban on the use of any non-competes by employers. Now, the proposed rule requires employers to rescind existing non-compete agreements with workers no later than their compliance date and provide notice to workers that their non-compete clauses are no longer in effect and may not be enforced. Individualized written notices must be provided to each currently employed worker, as well as former workers for whom the employer retains contact information within 45 days after rescinding the non-compete clause. And the proposed rule establishes a safe harbor for employers who use the model notice language provided in the proposed rule. Now, as defined, a non-compete clause would not include restraints during employment, nor would it include other types of common contractual restrictions, such as non-disclosure or confidentiality agreements, agreements for the repayment of training costs, agreements providing for the forfeiture of deferred compensation or benefits by competing workers, or agreements restricting a worker from soliciting clients, customers, or other workers. However, the proposed rule provides for a functional test under which such restrictions are prohibited if they act as a de facto non-compete by being so broad as to have the effect of preventing workers from seeking or accepting other employment following separation from their employer. Now, it's worth noting that in 2016, Congress passed and then President Obama signed the Defend Trade Secrets Act, or DTSA. The DTSA acknowledged that protecting trade secrets protects the company as well as its employees. And President Biden's goal is to eliminate all non-compete agreements except the rare cases in which a non-compete agreement is absolutely necessary in order to protect a narrowly defined category of trade secrets. While it's not clear what that means, it appears that under certain circumstances, employee restrictive covenants will be allowed. So the proposed rule probably didn't want to undo any of that. Now, this rule will probably only have a marginal effect on LOs, mainly applying to executives that would have entity effect and capabilities. Restrictive covenants are vital to our continually changing competitive business environment, where confidential information protection is becoming more critical. Nevertheless, companies cannot force extensive restrictions on all employees, especially if the primary purpose is to defer workers from exploring different employment opportunities. And I can give you an example here. It's very often either we are prosecuting or defending lenders who bring on new LOs, new branches, and usually the party who the branch or LO is leaving, it tends to be a little upset. They're looking for a reason why, and if they find out that something was done against the contract, against the restriction, they'll usually send a demand letter. We will usually send a demand letter to both the former employee as well as the potential employer. And in certain circumstances, you have seen litigation on this. It's really fairly common. Now, what tends to happen here, and we'll get into the data privacy and data security, is that a lot of LOs who do leave try to bring information with them. Or in one case that we had pursued, there was a branch who had left its employer and they took a pipeline of about hundreds of loans in the pipeline. And that was a huge no-no that subjected them to some huge liabilities. But with that, let's go into slide 40, titled Consumer Privacy. All right. Federal laws on consumer data privacy and data security cover various industries and individuals. Financial institutions are governed by the Gramm-Leach-Bliley Act, or the GLBA. The GLBA has gaps for different aspects of information security, and to cover those gaps, there are over 50 different non-federal data breach laws throughout the U.S. Multiple states have even enacted task force operations. Now, looking at California, which passed the California Consumer Privacy Act, one of the strongest state privacy regulations in the nation. And following in the footsteps of the European Union's General Data Protection Regulation, the CCPA's aim is privacy control and transparency in data practices. The CCPA declares that the right of privacy is an inalienable right, and fundamental to privacy rights is the ability of all consumers to control the use, including the sale of personal information. So while the CCPA only applies to residents of California, lenders nationwide will feel the effects of this new law. Now, the big question that lenders should ask, is there a legitimate business purpose for retaining the information? A business or service provider shall not be required to comply with the consumer's request to delete the consumer's personal information if it is necessary for the business or service provider to maintain the consumer's personal information in order to complete the transaction for which the personal information was collected. Provide a good or service requested by the consumer or reasonably anticipated within the context of a business's ongoing business relationship. Okay, next slide, please. Okay, the CARES Act legacy. I provide here, the definition of the CARES Act. And I see that we are just about out of time. So why don't we go ahead and skip over to slide 44. When you're looking over the CARES Act and the definitions, I put it all in there for you. And while I apologize for moving a little bit quickly, we wanted to make sure we packed as much information into this webinar for you as we possibly could. And in order to have any chance of getting through it, I'm having to move a little bit faster than I might otherwise. Now, what are the lasting effects of the CARES Act? Many in the industry predicted there would be violations of some kind that come out of all the confusion revolving around COVID-19 and the CARES Act. Now we get a glimpse into how. As I had mentioned, or as is put into this PowerPoint, key protections of the CARES Act were that mortgage servicers were required to provide forbearances of up to 180 days upon request, and borrowers were afforded certain credit reporting protections. The Consumer Financial Protection Bureau, or CFPB, investigated California-based Carrington Mortgage and imposed a $5.25 million penalty. The CFPB had found that Carrington violated the Consumer Financial Protection Act, and they misrepresented the requirements of the CARES Act and related federal agency guidelines. Now, the Bureau found that the company had misrepresented to borrowers that they could not have 180 days of forbearance upon request, and that certain borrowers could not have forbearances at all. Carrington also implied that homeowners had to make more detailed attestations than what were actually required by the law, and the company imposed late fees when they were not permitted to do so. Now, Carrington claimed for its part that the company acted in good faith and focused on delivering benefits to consumers. In its response and the news release, Carrington stated that it worked tirelessly to help borrowers in need, completing more than 134,000 forbearance agreements with its customers. But with a $5.25 million penalty, certainly they got more than just a small slap. Also, on December 20 of 2022, the CFPB fined Wells Fargo $3.7 billion for repeated legal violations. It's the largest fine the CFPB has ever imposed, and that just happened at the conclusion of last year. Now, according to the CFPB, Wells Fargo's illegal activity, in quotes, and widespread mismanagement included misapplying loan payments, charging incorrect interest and fees, and wrongfully foreclosing on homes and repossessing vehicles. This is just the latest in a long series of scandals that we have seen regarding this player over the past decade. For its unfair and deceptive practices, the CFPB ordered Wells Fargo to pay $2 billion to redress affected consumers by and the remaining amount into the CFPB's civil penalty fund. Okay, next slide, please. All right, fair lending and UDAP. While fair lending rules and regulations have existed for quite some time, we're starting to see a resurgence of regulators, both federal and state, focusing in on fair lending enforcement. As such, I want to provide a quick review of fair lending requirements in general. And so I walk through, again, given the time here, please go through, take a look at those requirements. I set it out in detail, and it's fairly self-explanatory there. Now, let's go to slide 47, effective fair lending programs. All lenders should have established fair lending programs. And that being said, as is the case with compliance management systems in general, a fair lending program can and should be tailored to the size and complexity of the lender's operation. A small lender will not be able to support or be expected to have the same complexity in a fair lending program as a national top-tier lender. However, there are many elements of a fair lending program that a lender of most any size can implement to help ensure compliance. And that includes comprehensive fair lending training for all your staff. And we always recommend that a lender has clear underwriting and credit guidelines that are easily accessible by all the underwriting staff and employees in general. We recommend a second review or 2 to say no is performed in all decline loans. And this is an easy mitigating control that you can put in place and help ensure all the borrowers are given proper consideration. Lenders should also have a formal process in place to track and monitor complaints. While this may not seem to be directly related to fair lending, tracking the types of complaints, source of complaints, and the loan specifics for each complaint can play a key role in helping your company to identify a pattern or practice of discrimination that you may not be aware of. What about for lenders that reach a certain size? It's important to note that they should ensure that you have an established and formal fair lending monitoring and testing program in place as well. As part of the testing program, we recommend conducting periodic reviews of pricing and underwriting exceptions. It's important to track and verify that any exceptions granted are not provided solely to non-protected class borrowers. Another key component of fair lending monitoring includes a credit quality control review of loan files, including declined loans. And this again will ensure that the decisions are fully complying with your published credit guidelines. And then finally, for more mature companies, we highly recommend conducting matched pair analysis. Matched pair analyses basically take two loan files with similar characteristics, for example, subject property located in the same state or area, similar loan amounts and employment status, and then compares the terms offered to protected class borrowers and non-protected class borrowers. And this will help identify if a borrower from a protected class is receiving a loan with higher fees, higher rates or APRs, and have a higher declination rate. Okay, going to slide 48, UDAP. The standards for deceptive, abusive acts or practices. Under the Dodd-Frank Wall Street Reform and Consumer Protection Act, all covered persons or service providers are legally required to refrain from committing unfair, deceptive, or abusive acts or practices. And again, this is better known as UDAP. Often, this is a tool the CFPB uses when it finds an unsavory practice that doesn't fit neatly into the other rules. For instance, as I had mentioned earlier, if the CFPB were to find that although a company is paying a loan originator the same compensation on every loan, the originator is nonetheless steering consumers into particular loans or loan terms that are not in their best interest, then the CFPB may look to see whether that practice is unfair, deceptive, or abusive, and whether the company knew or should have known about it. Okay, slide 50, audit preparedness. The selection of current Director Chopra signaled that the Biden administration planned to return the CFPB to a more prominent role as the early days of the CFPB inception. Now, with an increase in consent orders, just a couple of mentioned earlier, that seems to have come to pass. While the CFPB continues to reiterate its importance in regulation, individual states have also stepped in to maintain or even ramp up their exam process. New York, Massachusetts, New Jersey, Pennsylvania, and California have all launched a mini version of the CFPB designed to pick up the slack in areas that they perceive the CFPB as not being proactive in. And many other states have legislation to do the same in the works. The states will establish their own definition of what is or is not proactive enough. Audit preparation, next slide. A review of vendors, internal procedures, and activities in general is essential to an organization having a high level of audit preparedness. In the mortgage industry, the potential for an audit is often associated with either fear of uncertainty regardless if the auditing entity is a federal regulator, such as the CFPB, or a state agency or an investor. At the root of an audit is the intent to determine in mortgage companies whether they're complying with the guidelines designed to protect consumers. So what can you do to prepare? Understanding the need to build a sufficient compliance infrastructure before an auditor comes in to review is step one. Now, I'm not recommending everyone go through all 8 modules and do full, mock audits. But if you do have concerns on any particular area, it certainly would behoove you to, spend some time focusing on that and make sure it's done independently so that you're getting some real recommendations and not recommendations that are going to be biased, for someone that is internal. What are the elements? Going to slide 52, please. There's a few basic steps that you can use to help ensure your organization has the awareness auditors are looking for. Number one, prepare for the audit before it even develops. 2, start with a policy management program that includes comprehensive consumer coverage. Make sure your procedures and department level activity are aligned with your policies. understand your consumer data and flow of information, be effective at coordination, information gathering, and explanation. And then now moving to vendor management and oversight on slide 53. Look, while an audit can become a significant time burden and it's quite invasive, it's important to remember that unlike financial audits, regulatory auditors aren't there to analyze your bottom line. They're acting on behalf of the consumer, and this is why the CFPB and other regulators' examination manuals place an emphasis on inspecting a firm's practices to determine if any violations exist that can potentially violate the law or cause consumer harm. And as I had mentioned, your third-party monitoring is critical in the eyes of regulators to protect the consumer, which is why this should be a top priority in your compliance management program and audit preparedness. If interested, I've done a couple of webinars on vendor management. There's some good tips in there. If requested, I'll be happy to provide a copy of that prior PowerPoint. Again, with that, please feel free to reach out to myself or reach out to Tom, and I'll be happy to provide that. All right. Let's see here. Okay, let's go to slide 55, competitive disadvantage. Many calls that we receive start with, this company is doing this. Isn't that against the rules? How can they get away with that? Here I am following the rules. I'm losing business. What should I do? So the CFPB has released or put out a bulletin after bulletin reminding not just lenders, but brokers and all participants in the financial service industry to be cautious about any production incentives that might be offered to the employees or service providers, noting that the risks these incentives may pose to consumers are significant and both the intended and unintended effects of incentives can be complex, which makes the subject worthy of a more careful study by the institutional leadership. So what can you do to stay compliant and competitive? Well, first, you got to educate your staff and stay abreast of enforcement actions. It really helps when the staff understands why these rules exist and get them to buy in. So when a client comes to us and they say, hey, look, I'm losing LOs, or I'm afraid of losing LOs to, Joe Schmo down the street. They're offering this, they're offering that, but, we know that's not compliant. Okay, well, we know that Joe down the street may not be in business forever. They may end up getting hit. They may be taking a shortcut that gets them, a temporary financial gain. But one of the things that we do is come in and basically educate the LOs on certain things as to why it is not in their best interest to do something that is not compliant, whether for fear of their personal exposure or otherwise. And usually we have some pretty good responses from them when it's laid out, and it doesn't appear that we're just trying to, keep them from migrating over to a job that they may feel is better. Okay. I apologize for going over my time. I know we weren't able to get through every one of the slides I prepared, but I do hope that the slide deck will be valuable to all of you. And certainly if there are questions or concerns about anyone in particular, I'm very happy to go ahead and answer those, put together a follow-up FAQ. And look, it's not an easy subject matter. There's tons of different scenarios, tons of information, tons of regulations, too much in my opinion. But at the end of the day, that's our industry. And in order to have a chance of coming out the other side of this market and be competitive, it's extremely important to take those steps necessary to keep your company compliant now. So with that, I want to thank all of you for taking the time to listen to this webinar, and Tom for allowing me the opportunity to speak with you guys.
Well, our pleasure, James. I want to thank you for the whirlwind there. I mean, I know he couldn't go as in depth as you wanted to and everything, but you do a amazing job covering all the different components that you do. And a little hair over an hour here, and just reiterate great resources throughout the slide deck. we're going to be sharing that with all the registered attendees for today's call. We'll get that in email follow-up. I see David's inquiry in the chat there too. And then we'll also include the YouTube link to be able to replay this webinar on demand too, or be able to share it out with any internal resources that may not have been able to join us live today. And lastly, just reiterate James's point. Any questions from today's webinar that didn't get a chance to address here, feel free to shoot those direct via email to James or to myself. And we'll also capture everything that was laid out within the chat as well. But again, James, want to thank you for your time, everybody, for joining today, and hope you have everybody a great rest of your day and week.
All right. Hey, thank you.
Thanks, everyone.